First things first, Happy New Year and welcome to the Landmark Chambers webinar on asylum accommodation. We are delighted to see so many of you, by which of course I mean I'm delighted to see a long list of names. I can't actually see any of you. That's because your cameras and your microphones are off. We hope you find today's presentation and discussions useful and informative. If you have any questions, can you type them into the Q&A box and we'll try and pick them up towards the end, if that's all right. My name is Justin. I'm the chair of the session today. I'm joined by my colleagues who hopefully you can see, Hafsah and Alex. There's us. I'm waving in the background there. I'll introduce everyone properly in a moment. We were supposed to be joined today, for those of you who were paying attention, by Admas as well, but he's come down with something horrible over the weekend and is unfortunately not able to make it. And I was also hoping to do this from London, not from my cold attic, which is where I seem to have spent the last 2 years. But I'm afraid COVID and homeschooling strikes again. So here we are. In terms of some housekeeping, your microphones are automatically muted, so please don't adjust your local settings. We are very keen to have questions throughout the session because that's how these things become both interesting for us and useful for you. So please type them into the Q&A box as we go along, and I will try and pick them up towards the end. There's an option for sending anonymously if you want to send an anonymous question in. So that may be something you want to look at. We will try and get to those questions towards the end. The plan is to have 10-15 minutes at the end for picking things up. The webinar is recorded and you will receive a link to the presentation and the recording probably this afternoon or first thing tomorrow when it's all formatted and ready to go. And if you lose your connection at any stage, just rejoin by clicking on the original link. There's nothing else you need to do. So, starting with introductions then, start with Hafsah, who you will be hearing from shortly later on. She is an incredibly experienced immigration practitioner who has acted in a number of significant asylum support cases in the last year, including Secretary of State for the Home Department and the First Tier Tribunal Social Entitlement Chamber, which was all about the Secretary of State's obligations as regards the provision of accommodation to destitute failed asylum seekers as part of the roadmap out of lockdown. AGX and Secretary of State for the Home Department, all about the policy on provision of financial support to asylum seekers in full board accommodation. And she's going to be talking about that a bit later on. And she's acting currently in a long-standing judicial review of the Secretary of State's systems and policies on pregnant and new mothers in asylum seeker accommodation. Alex, who is, at least on my screen, is underneath Hafsah and is now waving, has an incredibly broad public law practice covering immigration, community care and environmental law. I see he's chosen not to mention his public law housing work because that involved he and I going to the Court of Appeal and just getting kicked around for half a day. He's been instructed by individuals and families in many Section 95 and 98 and Section 4 accommodation cases, and he's currently acting on several challenges in relation to proposed asylum seeker accommodation camps on military sites. He's acting in the environmental challenge to the expansion of the Napier Barracks in Kent. And then there is me. I am the editor of the Encyclopedia of Housing Law. I'm the author of the last 3 editions of Homelessness and Allocations. And my actual knowledge of asylum accommodation is very limited, but my knowledge of how local authorities engage with that should hopefully be quite useful for people. The plan is to do about 15 minutes each. And that's become slightly more fluid now that Admas isn't there, leaving us with 10-15 minutes towards the end for questions. And so let me start by talking a little bit about local authority asylum accommodation duties. Right. Local authorities and asylum support has been a bit of a hokey-ish scenario because historically, by which I mean from 1977, when the Housing Homeless Persons Act was passed, through to the early 1990s, there was actually nothing to exclude asylum seekers from homelessness support. Under what's now Part 7 of the Housing Act 1996 if you're in England, or Part 2 of the Housing Wales Act 2014 if you're in Wales, but what was previously the Housing Homeless Persons Act 1977 and then the Housing Act 1985 that reenacted most of it. And you've got a couple of cases there on the slides, mainly for historical interest, Streeting and then Castelli, situations where asylum seekers or failed asylum seekers nonetheless qualified for homelessness support. But since the early 1990s, the general trend has been to try and keep asylum seeker cases away from local authorities, certainly away from Part 7 and the homelessness provisions. The Asylum and Immigration Appeals Act 1993 was the first significant intervention, and now if you want to see how the limited role that asylum seekers play in Part 7 accommodation, you need Section 185 of the Housing Act 1996, and then the allocation and eligibility regulations that are made thereunder, or the Welsh equivalents thereof. Essentially, and for the local authority lawyers in this who do housing work, I apologise for the gross oversimplification, but essentially, if you're not British or Irish, Section 185 says you don't qualify for homelessness support unless you're in a category of person that the Secretary of State then re-includes. And those re-inclusions, until April 2000, included asylum seekers by Class E. But since April 2000, there hasn't been an asylum seeker re-inclusion, because the drive has been to try and have asylum seekers and failed asylum seekers as the responsibility of the Secretary of State, as my colleagues will talk about later, rather than having them in local authority support. Interestingly, although the policy of the last, 20 odd years has been to keep asylum seekers out of Part 7 homelessness support, there's this really weird interplay between how Part 7 homelessness support works and Part 6, the allocation of social housing, works. Because one of the ways of helping a homeless person is to allocate them social housing. So offer them a secure tenancy from a local authority or an assured tenancy from a housing association, or since the Localism Act 2011, you can do it by finding certain kinds of private sector accommodation for them. Now, given that asylum seekers aren't supposed to be helped under Part 7, you might think they're also not supposed to be helped under Part 6, which is the allocation of social housing. And you'd kind of be right, because like homelessness provision, there's a list of people who are eligible for an allocation of social housing, and it's supposed to exclude asylum seekers. Except, human nature being what it is, mistakes get made from time to time. And people who are not eligible for an allocation and who are not eligible for assistance under Part 7, nonetheless get allocated social housing. And the law's got itself into this, at least to my mind, slightly weird scenario where giving support to someone under Part 7 or allocating them housing under Part 6 is ultra vires if they are asylum seekers, because they don't fall within the eligible categories. But nonetheless, if you do, as a local authority, manage to mistakenly allocate social housing to an asylum seeker, that doesn't, the ultra vires nature of your public law allocation doesn't affect the private law validity of the tenancy. You can see a case called Akimbola and Hackney from 1996 to that effect. And then there's a slightly more detailed discussion in a case called Kazim and Birmingham that I managed to lose about 15 years ago. And that's because the private law tenancy is not affected by the public law error. So it's perfectly possible to grant an asylum seeker a secure tenancy by mistake. And that happened, may have happened recently, in a case called Ibrahim and Haringey that I just flag up there. Ibrahim and Haringey arises in the context of something called the Everyone In programme that I'll talk about on the next slide. But Mr. Ibrahim he's either an asylum seeker or a failed asylum seeker. It isn't entirely clear. And he's been sleeping rough in Haringey's area. He goes to the local authority for help, and they give him accommodation in a self-contained flat. A couple of days later, they realise that was a mistake on their part, because he's excluded from homelessness assistance because he's not an eligible person because Section 185 excludes him, and he's not within one of the reintegration categories of the Secretary of State's regulations. So they realise that they've been housing someone they're not supposed to be housing, and they try to evict him. And he says, well, you can't do that. He says, I have got a secure tenancy. You have let me a property. I occupy it as my only or principal home. That is, you are a local authority. That is the definition of a secure tenancy. So you can't get me out unless you can establish a ground for possession. And in another 18 months or so, I'm going to qualify for the right to buy, which I might well think about exercising. The local authorities say, no, you can't do that. This has clearly been given to you as a mistake. You are not entitled to any kind of support under Part 7 or Part 6. This is some gratuitous charitable act on our part, and we want to evict you. He goes for an injunction to prevent what he says would be an unlawful eviction. The county court judge rules against him and says, no, it's ridiculous. You're obviously not entitled to be supported in this way. This is a clear mistake. you've got to go. But the High Court says no. The High Court says no, it's perfectly arguable that he's got a secure tenancy. The fact he wasn't supposed to be helped might be a public law problem for the local authority, but if he's been granted a tenancy, it's valid in private law. And if it meets the conditions to be a secure tenancy, it is a secure tenancy. And he will have the security of tenure and the right to buy in due course and such like. So there's a discussion there in Ibrahim and Haringey about how people who aren't supposed to be helped nonetheless do get helped, and what might happen in practice if they do get helped. Now, the interesting bit in Ibrahim and Haringey, because of course it was only an interim injunction in the county court, which the High Court said could and should have been granted. He has subsequently been evicted, albeit he says it's an unlawful eviction. And so he's currently got a money claim against the local authority, which, as I understand it from counsel acting in the case, they value at just over £600,000 for his unlawful eviction from a secure tenancy. And it'll be very interesting to see how that pans out in due course. For the local authority lawyers listening to this, the answer is, of course, please don't grant tenancies to people who are asylum seekers and who don't qualify for support under Part 6 and 7. But if you do, then all kinds of problems might arise. Having started off by saying local authorities aren't really supposed to have very much of a role in dealing with, at least under the housing legislation, dealing with asylum seekers, I want to flag up the COVID context, because this is potentially quite a significant change in approach. It'll affect a relatively small group of people, but the change is quite significant. So back in March 2020, the government sent a letter to local authorities in England, which became known as the Everyone In scheme, where the central government told local authorities, find accommodation for your rough sleepers. It doesn't matter about their immigration status, just house them for their own protection and for wider public health benefits. But how do you do that as a local authority if you're not doing it under Part 7? And if it is under Part 7, you can't do it for people who are asylum seekers because they don't qualify for support. So that was N-Cube and Brighton towards the end of last year. N-Cube's a failed asylum seeker who was sleeping rough in Brighton. And in September 2020, he approaches the local authority for assistance, and he refers to the Everyone In letter. And he says, look, I'm sleeping on the streets in COVID. Secretary of State wants you to provide help. Brighton say we can't. They say you're a failed asylum seeker. You're excluded by 185, and you're not within any of the requalified categories under the regulations. So we can't help you. And so he issues a JR claim, and he says, no, you've got 3 powers to help me. Section 138 of the Local Government Act 1972, Section 2B of the NHS Act 2006, or Section 1 of the Localism Act 2011. By the time of his JR, he's been accommodated by the Secretary of State again. So there's a bit of an argument in the case whether it's academic or not. It's not, because of the public importance issue. And the High Court finds that local authorities have certainly 2, possibly 3 powers to help people who are asylum seekers and who can't be helped under Part 7. The first is Section 138, where local authorities are entitled to incur such expenditure as they consider necessary to avert, alleviate, or eradicate the effects or potential effects of an emergency or a disaster. Now, the High Court says, look, COVID obviously falls within that category. It's certainly an emergency or disaster. Why wouldn't you want to house someone to ensure that neither they nor the wider community are affected by the spread of the disease? As long as you don't use it for the unlawful purpose of avoiding Section 185, that would be a perfectly legitimate thing for local authorities to do. Second power is the NHS Act. So the local authority has a duty to take steps as it considers appropriate to improve the health of the people in its area, which can include providing assistance to help minimise a risk to health arising from your accommodation or your environment. Well, that's a power, says the High Court, to help anyone who is sleeping rough. That's plainly engaged by COVID, and it's not limited. And as long as you don't use it for the purpose of avoiding Section 185, that will be fine. I'm just pausing there for a minute. 13872 Act is obviously fairly limited in practice. There's a reason there are precious few cases on it before this year. It's because there haven't been a lot of national emergencies or disasters that needed housing intervention. But the 2006 Act is potentially much broader, because that's not limited to emergency or disaster. It's any risk arising out of your accommodation or environment. So that's potentially much more important for local authorities. And then on the third one, the High Court slightly ducked the issue, which is the Localism Act. This is the power to do anything that a private individual could do, save that you can't use it to do something that's prohibited by an earlier provision. Now, that wasn't available, said the High Court, because Section 185 of the 96 Act is a pre-existing prohibition. So you can't use Section 1 to provide housing. However, the answer might be different if the only way to avoid a breach of the Human Rights Act was to use the Section 1 power, although that didn't arise in the facts of N-Cube because the two earlier powers had been identified and he was actually being accommodated by the Secretary of State at the time of the hearing. But that issue, what they left open there, is quite an important one. Again, local authorities need to be aware of. Now, you may think this has all been slightly overtaken by the at least relaxation, if not improvement, in the COVID position. But you wouldn't be quite right, because at the end of last year, the Minister for Rough Sleeping wrote to local authorities again, urging them to take part in what he calls the Protect and Vaccinate programme, where he says you should make offers of safe and appropriate accommodation to people who are sleeping rough, particularly in order to assist them with obtaining coronavirus vaccination. And he comes out and he expressly says you can do that regardless of immigration status, relying upon the two powers that the High Court said were fine in N-Cube, so the 2006 Act and the 72 Act, and then Section 1 of the Localism Act, if it's necessary to avoid a breach of the Human Rights Act. So the government's current position is slightly further and slightly more expansive than the Secretary of State took in N-Cube. Now, importantly, and the last point for me here, these powers are not limited to COVID. One of the points we make, if you're very interested in the homelessness and allocations book, is although obviously context is driving these powers and this judgment is going to be relevant forever until the powers are reformed or abolished. There are plenty of scenarios you could imagine where the 2006 Act or the Section 1 2011 Act could be engaged. The 72 Act probably more limited because of the emergency requirement. You can certainly imagine those coming in. And what I suspect will happen over the next 5 years or so, from a local authority homelessness perspective, is people that you reject on the grounds of Section 185 exclusions will nonetheless ask you to consider your Section 2B or Section 1 powers and either challenge the decision you reach, or if you decline to do so, challenge your refusal to do so by way of judicial review. So it seems to me that having tried to get local authorities out of the business of providing asylum seekers with support since 1993, what we actually see now is a potential opening of the door, at least in some circumstances, for some kinds of asylum seekers. Let me move on now to Alex, who will cheer you up with some thoughts on temporary asylum accommodation.
Brilliant, thanks, Justin. Hello, everyone. I'll be talking to you about temporary asylum accommodation and delay. And basically, as a destitute asylum seeker, you may be entitled to accommodation from the Home Office, but if you make your application that's successful, before you get placed in, say, a flat, you may need to spend some time in a hotel or a hostel or somewhere else before that flat becomes available to you. And pretty straightforward, and of course nothing wrong with it in principle, although as we will see in practice, problems emerge. Temporary asylum accommodation has been in the news recently. I don't follow any sport at all, I'm afraid, but apparently this famous footballer didn't want to get vaccinated, and so Australia put him in Australian asylum accommodation, which was great because it illustrated to the world just how bad this accommodation can be sometimes. And I think he only lasted a few days. And of course, it's not just Australia. Some of the UK hotels that asylum seekers are being put in are not, as has been suggested to me in summary grounds of defence, a 4-star experience. This is the Crown Plaza Hotel you'll see here on the slide. I've been instructed in 4 or 5 judicial reviews about this one hotel near Heathrow, and things got pretty bad there, I think it's fair to say, although I am pleased that after quite a few legal challenges, the conditions began to improve. Thanks. So this is just an outline of my talk. We'll talk about the legal framework, how to bring a challenge, grounds of challenge, and some top tips for claimants. So there are two main, I suppose, legal regimes, provisions for what I consider to be asylum accommodation, both under the Immigration and Asylum Act 1999. You have the Section 95/98 accommodation, which is for those people with asylum claims pending, and then you have Section 4, which is for failed asylum seekers. So turning first to Section 95/98, which is on this slide. So Section 95 is the permanent accommodation, Section 98 is the temporary accommodation. And in terms of how you frame the challenge, there's little distinction really between the two, and I just tend to plead both. It's not like once you're out of the hotel, you need to bring a different challenge or anything like that. I think the distinction between the two, fairly vague, porous, and flexible. So, yeah, and that's just Section 98 there. So Section 4, so for destitute people who are appeal rights exhausted, there's Section 4 of the Immigration and Asylum Act 1999, similar kinds of accommodation, but they get less support, as I understand it, and the test to obtain it is much harder. Basically, you have to show that you've got a pending judicial review, a breach of human rights not to provide the support, etc., etc. There's a fairly short list there. There are several kinds of challenge which I set out on this particular slide. The kind of challenge I'm focusing on here in this presentation is where a duty to provide Section 95/98 or Section 4 accommodation has been accepted by the Home Office, but there has been delay in giving it to them, to your client, delay in the permanent accommodation, or alternatively what they've been put in is unsuitable. And often you'll have a situation where people can be stuck in unsuitable accommodation or stuck in a hotel or hostel for many months before they're moved on. And you'll see on the slide there, this has been very bad recently due to COVID, because the flights out of the UK for failed asylum seekers have stopped, or they had stopped for quite some time, and so the asylum system, accommodation system, effectively became overloaded with people for a considerable period of time. And the result of this was, whereas previously the Home Office might put, say, a family of 4, family of 5 in a hotel room for a night or two maximum, I've had some cases where families have been stuck in single hotel rooms for up to 9 to 10, 11 months. Although, to be fair to the Home Office, since the middle of last year, many of the younger families, more vulnerable families stuck in that limbo position have now been dispersed. And my more recent clients in this area have been individuals rather than families. Another problem you'll see on this slide, which is not COVID related, is outsourcing. This applies to both Section 95/98 and Section 4 accommodation. Basically, the Home Office have set some pretty stringent requirements for accommodation contracts, which is great, but these contracts are all being carried out by private sector providers. The main ones are Serco, Clear Springs, and another one, can't remember the name. And it's fair to say that they have a very poor track record. In a case I was involved with in the High Court, DMA and others, the judge agreed that the Home Office wasn't monitoring their Section 4 contracts properly, and the contractors were largely not doing the job that they were being paid by the taxpayer to do. So you have a client who's been stuck in a hotel or a hostel for too long, or it's clearly unsuitable, no sign of dispersal or moving on to permanent accommodation. What do you do? Well, in those circumstances, what you do is bring a judicial review in the admin court with an application for interim relief. And what you ask for is a mandatory order to provide adequate accommodation within a short period of time. And you might get a relief decision on the papers, you might get an interim relief hearing pre-permission, or you might get an interim relief decision as part of a paper permission decision within a shorter period of time. Of course, there's a permission stage for judicial review. I've seen all three. It depends on the facts and it depends on the judge. How do you frame a challenge to a failure to move an asylum seeker out of a hotel or hostel? Well, unreasonable delay is the main ground of challenge. Last year, we were refused permission on a challenge based on systemic delay, trying to argue the whole system was broken, but the judge was very clear in refusing permission that delay is very fact specific. So it's about whether you can show enough evidence that the Home Office are being unreasonable in the length of time that they're taking on the facts of your client's case. If children are involved, then Section 55 of the Border Citizenship and Immigration Act is a good one, as the duty to have regard to the best interests of children. See Lady Hale in ZH Tanzania. Disability or other Equality Act discrimination is also a good one, and try to plead Equality Act discrimination where you can, where it's justified, not least because this allows you to ask for damages. You may also want to argue breaches of Article 8 and or 3, which will also allow you to ask for damages under the Human Rights Act. But in these kind of cases, Article 3 is much harder, and it has to be really pretty bad in order to run that ground. While we're on damages, I would say don't go overboard with damages, particularly in the Section 95, 98 cases, as opposed to Section 4 ones. Basically, delay in the Section 4 ones is much worse, because if there's a delay in a private contractor picking up your client, then they could be on the streets for 1, 2, 3 days or longer, rather than being stuck in a rubbish hotel, which at least they've got a bed to sleep in. And the DMA case that I mentioned before gives a good indication of the amount to ask for. You're looking really in the sort of £1,000 to £2,000 range, if that, even in the Section 4 cases. So if you're winning a Section 95, 98 case, just be realistic. You're not going to get 20 grand, say, for your clients. So top tips for claimants then. Firstly, get your evidence sorted. You need a good witness statement and ideally some medical evidence. Letters from doctors can be helpful, not just saying the client has severe issues, but linking those issues to their accommodation situation specifically. And for example, we commissioned a dietitian for a number of families stuck in hotels, in Crowd Plaza Hotel in particular, to show that the food they were being provided with was not nutritionally adequate. It was basically extremely cheap ready meals provided by the private contractors. No fresh fruit or vegetables. We're talking chicken nuggets and baked beans, that kind of stuff. And our dietitian said the quality and the nutritional value was so poor it was making our clients ill. And it's very useful to hear that from an expert and to be able to put that in front of the court. You also need to put any medical evidence to the Home Office, ideally in your first pre-action protocol letter, but a follow-up pre-action protocol letter if necessary before issuing your judicial review. Otherwise, once you get interim relief and we start talking about settlement and costs, the Home Office might say, well, of course, if we'd had this evidence before you issued, there's no way we would have resisted this claim. I have heard that before. So ideally, always give them a chance, as it were, before issuing. So try and commission your evidence first, although depending on the severity of the situation, that might not always be possible, of course. Interim relief then, with these kinds of cases, an interim relief application is almost always appropriate, and indeed obtaining interim relief is probably your primary objective with these kinds of cases. However, be careful about timings. If your claim form says this is so important that the out-of-hours judge needs to get out of the bath on a Sunday to consider it, and it turns out that's not the case, you can get in big trouble. A very angry and very soapy judge may well summon your barrister to explain what the hell you're playing at. So think carefully about the facts of your case and the factors that may or may not justify more urgent consideration. Are we talking immediately? Are we talking 3 days, 7 days, or longer? For example, I had a Section 4 case where a mentally ill lady was going to be made street homeless the following day. That is definitely a case for immediate consideration. I had another one where the hotel my diabetic client was placed in didn't have a fridge for him to store his insulin in properly, so it was very seriously affecting his health. I think he had to store it on the windowsill. So again, that justifies very urgent relief. Young families tend to justify urgent relief too, because the children need somewhere reasonable to live, not just a hotel room. They need to register for school. And of course, until they're dispersed, they don't know what part of the country they're going to be in to register for a school. But if your client is, say, a single adult male and say the only issue is mental health problems, then you may need to be more realistic. And now if you ask for over 7 days, you can't use the N461 form. In the admin court, you need to use a standard N244 application. And what I do in those cases is say on the N244 form, look, we're being reasonable, asking for consideration in, say, 2 weeks. But if his mental health conditions get worse, let's say he starts self-harming or something like that, we reserve the right to file a further N463 asking for more urgent consideration. It's all about being reasonable, really, in terms of the timings you ask for. So in sort of making your interim relief claim and in the hearing itself, it's important to know what the test is, and in reply, the Home Office often like to say, well, you're asking for a mandatory order against a public body, so it's not just the modified American Salamid test for interim relief. You may recall from law school. You also need to show a strong prima facie case of unlawfulness, and then maybe they'll cite an old Court of Appeal authority from the late 90s, perhaps back when Steps and Cotton Eye Joe were still on the radio, back when radio was a thing. But just as video killed the radio star, so too has the law on this moved on regarding mandatory interim injunctions, and that goes for injunctions against both the Home Office and indeed local authorities. There is no carve out in the Admin Court Guide for mandatory injunctions. They're treated the same as any other. The test is still whether there's a real issue to be tried and whether the balance of convenience lies in favour of granting the order. And there's a recent helpful age assessment case on this, AS in Liverpool, which I've put on the slide, where this argument about strong prima facie case was run by a council and basically failed. There's no higher bar for a mandatory interim injunction. If the injunction you ask for is onerous, more onerous than a non-mandatory injunction, and that is just a factor that can go into the balance of convenience part of the test, but it doesn't change the test. Another case that I like to cite on the interim relief application form is K and Secretary of State for the Home Department. I mostly like to cite this case because I was in it, but occasionally it is useful as well. And it's useful when the Home Office say to the judge, well, your decision should favour the status quo, see American Salamid. The status quo here is not granting the order. Now, K was a reported interim relief hearing for a family stuck in a hotel room for many months, and the newborn baby had to sleep on the floor because no cot had been provided, so pretty grim. And the judge said this: the Secretary of State puts forward that the status quo is leaving the family where they are. In my judgment, that would not be maintaining the status quo. The status quo must be for the Secretary of State to comply with her duties. So not a binding decision, only an interim relief hearing, but a nice little quote to reel out if you need it. And so what happens when you get your interim relief? Let's say you're successful. Do we press our advantage? Do we really take the Home Office to town in the final hearing? Well, unless you're also running a systemic challenge, the answer is probably no. If you get interim relief, you should probably aim to settle with your costs paid before permission. This is because the Home Office will invariably argue that once your client has been moved to a better flat, the issues in the case are now academic, which can be a difficult argument to deal with. As I say on the slide, don't settle too soon. You want to confirm the accommodation your client is being sent to is adequate, and you can't be too fussy. And remember, it is allocated on a no choice basis, so it could be anywhere in the country. But I have, for example, had a case where they tried to move my client out of a hostel into a house which was not wheelchair accessible, and indeed he couldn't get his wheelchair through the door. So it's important to confirm where they're sending him and that it is suitable before you agree to settle the legal action. If you pleaded damages, that can come in at this stage. The damages claim can potentially survive and be transferred to the county court, but you probably need to redraft the pleadings quite significantly. That's quite a lot of effort for what is likely to be a small amount of compensation owed under the Equality Act. So better, in my view, to settle for a modest sum once you've got what you asked for. And I believe that is the end of my talk. So I'll pass you on to Hafsah now.
Good morning, everyone. My name's Hafsah, and I'll be speaking about financial support for asylum seekers. Now, both Alex and Justin have focused on accommodation and housing, and it's certainly fair to say that in most cases that will be, for obvious reasons, the immediate and significant need for a destitute asylum seeker. But asylum support can also extend to financial support, particularly for essential living needs, and that's the term that's used in the legislation, and we'll come on to look at what it means in more detail. And what I intend to do is first of all provide a brief overview of the legal framework, and then I will provide an outline and discuss two recent cases challenging the Secretary of State's policy, which was announced towards the end of 2020, relating to the provision of financial support to asylum seekers in full board initial accommodation. So it's a type of accommodation that Alex has been speaking about. So Alex has already touched on Section 95. It's section 95 that contains the power on the part of the Secretary of State to provide or arrange for the provision of support. So that's a term that's used in the legislation for asylum seekers and their dependents. And I've set out there the definition of destitute. So that's the power, to whom the duty is owed. And the reason I set it out is just to highlight that destitution is not only when a person doesn't have adequate accommodation, but can also extend to those who have adequate accommodation, but can't meet their other essential living needs. So under section 95, support can be provided in a number of ways. It can be provided by providing accommodation which is adequate for the needs of the supported person, and or it can also extend to providing what appear to the Secretary of State to be essential living needs of the supported person and their dependents. Now, section 96, and in fact the Immigration and Asylum Act, doesn't say how support for essential living needs is to be provided. But that is addressed in Regulation 10 of the Asylum Support Regulations 2000. And these provide that where the Secretary of State has decided that asylum support should be provided in respect of essential living needs, as a general rule, it may be expected to be provided weekly in the form of a weekly cash payment in the specified sum, which as of February of this year is £39.63. And we'll come on in a moment to look at how that figure is calculated. And it's also important to note that that sum is payable as a general rule, so not invariably, but as a general rule, to asylum seekers and each and every dependent. That figure is payable to adults and children alike. Subsection 3 is important for reasons that will become clear. This says that where the Secretary of State has decided that accommodation should be provided by way of support, and the accommodation is provided in a form which also meets other essential living needs. So, for example, it's provided on a full board basis. The figure in subsection 2, which is £39.63, shall be treated as reduced accordingly. The two cases that I mentioned at the start, the two recent cases about the provision of financial support and full board accommodation, those cases, this provision assumed particular relevance in those cases, so we'll come on to look at it in more detail in a moment. But just to note also that although I'm going to focus on those supported under section 95, failed asylum seekers supported under section 4.2 also receive a weekly allowance to cover essential living needs in the same amount. So first of all, essential living needs, what are they? Regulation 9.4 of the Asylum Support Regulation sets out a list of items and expenses which it says are not to be treated as essential living needs. So that includes the cost of faxes, which isn't of particular modern relevance, computers and cost of computer facilities, photocopying, travel expenses, although that's subject to certain exceptions, toys and recreational activities, and also entertainment expenses. So those cannot be treated by the Secretary of State as essential living needs. But otherwise, subject to Regulation 9.4 and subject to the minimum required by the Reception Directive to the extent that it continues to be relevant, it's essentially a decision for the Secretary of State, and the courts have recognised that it involves a value judgment. So what is and is not an essential need, i.e. what's a need and whether or not it's essential, that involves a value judgment, and it's a decision for the Secretary of State to take. And it's only reviewable by the courts on ordinary judicial review principles, so Wensbury unreasonableness, etc. So how is it that the Secretary of State decides what is and what is not an essential living need? Well, the Secretary of State carries out a periodic review using an assessment methodology which was developed in response to a High Court decision called Refugee Action, and you've got the citation there. It's quite an interesting judgment actually, and worth a read. it was a methodology that was accepted as lawful in the case of JK Burundi. The basic approach is to identify all the needs which are considered to be essential for the average able-bodied asylum seeker and their dependents, and which are not covered through other arrangements, for example, powers and duties on the part of local authorities and other organs of state. And once those needs are identified, the Secretary of State then assesses the cost of meeting each of those needs. The last review was quite recent. It was in 2020, and the one before that was in 2017. If you're interested, and it is a voluminous document, the report, and you've got the heading and the title there, it is available online, and it sets out in detail, for example, how the Secretary of State assesses the cost of meeting each need, and the research, the market research and other data that's been used to come to the figures, and we'll look at the breakdown in a moment. I'm now going to attempt to launch a poll. I hope everyone can see it. So there's a list, and the question is, which of the items below are not adjudged by the Secretary of State to be essential living needs using this methodology? So in other words, which of the items on the list are not essential living needs according to the Secretary of State? And just to help you out, there are 3 items on that list which are not adjudged by the Secretary of State to be essential living needs. So I'll give you about 20 seconds just to identify which you think are not essential living needs, or which you think the Secretary of State doesn't think are essential living needs. Okay, so the needs, I've tried to share the results. I hope you can see them. It looks like there hasn't been much uptake, and it might be a fault at my end and not, I hope I've managed to upload the poll. But the needs, if you can see the list, the needs which aren't essential living needs are unsurprisingly alcoholic drinks. So that's a need, that's an item which the Secretary of State unsurprisingly doesn't recognise as an essential living need. Travel to and from shops is not recognised as an essential living need, although travel to meet other needs is recognised as an essential living need. And the reason why travel to and from the shops isn't recognised as an essential living need is because in refugee action, the court thought that the Secretary of State was entitled to treat, as in fact she does, the cohort of asylum seekers for whom support is provided for essential living needs as able-bodied. And the Secretary of State might reasonably expect able-bodied person to walk to and from shops. And if, because of their specific circumstances, either because they live too far away from the shops or because they have a disability or they're unwell, which means that they can't walk to the shops, then that's something that would fall for consideration as an exceptional case. And a person would need to apply for additional support under section 96(2), which I set out, I think it was on the 2nd or 3rd slide. And anyone wanting to apply for additional support over and above the general support that's available can do so by making an application on it. There's a form online, it's called the ASF2, the last time I checked. The other item which isn't recognised as an essential living need is educational material and school uniform. School uniform isn't covered because school uniform grants are normally provided by local authorities. And if for whatever reason a grant isn't available, then this too would fall to be considered as an exceptional case. Educational materials such as books is also not covered as an essential living need, but it's worth bearing in mind, for example, that note, paper, pen, so writing material, is factored in actually into the communications allowance. So those are the essential living needs. Most of them are pretty obvious. Just worth noting that travel and communication are not considered by the Secretary of State to be essential needs in themselves, but may be necessary, the Secretary of State recognises, in limited circumstances to enable other needs to be met. So that can include maintaining interpersonal relationships and a minimum level of participation in social, cultural and religious life. And there you'll see a table which sets out the sums that are allowed both in the 2018 review and the 2020 review. So that's the recent review and the recent figures, or the most up-to-date figures. So it shows the sums allowed or assessed to be essentially the cost of meeting each of the needs which are identified by the Secretary of State as essential living needs. And you'll have spotted that the total figure, so the £39.63, that's the figure that's then prescribed in subsection 2 of Regulation 10 of the Asylum Support Regulations. Going back to Regulation 10, a person supported under Section 95 will generally receive a weekly cash payment in the specified sum, but that won't invariably be the case. And you'll remember Regulation 10.3, which said that where accommodation is provided in a form which also meets other essential living needs, the specified amount shall be treated as reduced accordingly. So the Secretary of State's long-standing approach has been not to pay the weekly cash payment to those in full board accommodation, and that's on the basis that their essential living needs are either met through the support package provided in full board initial accommodation, or their needs that don't arise on a short-term basis. So, for example, and I think Alex touched on this, that if you're in an initial accommodation which is provided on a full board basis, accommodation providers are contracted or are contractually required to provide, for example, 3 meals a day. So the essential need for food and drink will be met through provision in kind. The same is true for toiletries. Toiletries are generally provided by accommodation providers who are providing full board initial accommodation. So the reason for the Secretary of State's long-standing approach not to provide any cash allowance for those in initial accommodation was that their needs would be met either in kind, such as through the provision of meals, or sometimes initial accommodation providers also offer vouchers to the extent that they can't provide a particular item or service in kind. Now, the pandemic changed things to this extent. There was announced on the 27th of March a pause on the cessation of support, which went right into 2021 in some form or another. And that resulted in a shortage in supply of dispersal accommodation. So it affected turnover, it resulted in a shortage of dispersal accommodation. It resulted in, therefore, a greater use of contingency hotels, and also generally people spending significantly longer in initial accommodation. There's a National Audit Office report for anyone that's interested, which was published in July 2020, which says that between September 2019 and February 2020, so that's obviously immediately before the pandemic, on average, people were spending 26 days in initial accommodation before leaving, i.e. being dispersed. And this was in line with the Home Office's expectation of up to 35 days in initial accommodation before dispersal, but it recognised that some people did stay much longer. And as I say, and as Alex touched on, during the pandemic, people were generally spending much longer in initial accommodation. And if you're interested in the full background and the reasons, there's an account of the Secretary of State's evidence in the case that I've cited at paragraphs 35 onwards. Now, because people were spending much longer in initial accommodation, the Secretary of State decided that she would depart from her long-standing approach. And on the 27th of October, she announced a decision, which I summarised there on the slide, which was that going forward, a weekly payment of £8 would be made to those in full board initial accommodation. And that was made up of the cost of clothing, non-prescription medication and travel. It didn't include anything for communication, clothing, accommodation, toiletries, etc., because it was thought that the accommodation provider would continue to provide for those other essential living needs. And then in addition to a weekly payment of £8 going forward, the Secretary of State decided that those in full board accommodation during the relevant periods would also receive backdated weekly payments of £3 for the period 27th of March 2020 till the 30th of June, and that was for the cost of clothing. Nothing was included for travel, although it was included, provision was made, as you can see from the second bullet point, for the latter period. Nothing was included for travel in the period 27th of March 2020 until 30th of June, because it was thought that due to COVID restrictions, it was generally inappropriate in this period to travel. Nothing was included for non-prescription medication or other essential living needs on the basis that those were met or would continue to be provided for by accommodation providers. Now, this resulted in a number of legal challenges. The first was a case called JM. I'm just looking at the time, and I'm fairly short on time, so it's going to have to be a whistle-top store overview. JM was a case in which the claimant was in full board accommodation between 1st of May 2020 and 1st of Feb. So a fairly lengthy period, and he claimed that the Secretary of State's decision of the 27th of October was deficient in two respects. First of all, he challenged the Secretary of State's decision not to make any backdated payments for travel in respect of the period 27th of March to 30th of June. This was on the basis that it was said that the Secretary of State's assessment that travel was generally inappropriate in that period was irrational. And then it was the Secretary of State's decision not to include a sum for communication was also challenged. There you have the result. Court decided that the Secretary of State's decision on in relation to travel was unlawful. It went through all the restrictions that were in place during the relevant period and agreed that either the need for travel was greatly reduced or it was reasonable for the Secretary of State to expect people to stay local. As to communication, that the failure to include a sum for communication was unlawful. And this was on the basis that the Secretary of State, the court thought, failed to have proper regard to the communication needs of asylum seekers. And this was because the court thought that the Secretary of State had wrongly or unjustifiably proceeded on the basis that the communication need was being met because most asylum seekers had mobile phones, which in combination with the availability of free Wi-Fi in hotels would mean that the communication need would be met. Court didn't agree and made a declaration, but left it to the Secretary of State to decide what needed to be done. As I understand it, Secretary of State this decision only came out at the end of last year, and Secretary of State hasn't yet amended her policy or published her decision about what she intends to do about the unlawfulness that's found. Second challenge was a case called AXG, which was only handed down on Friday, and it's a case in which I'm acting for one of the parties. This, in addition to challenging, bringing the same challenges in JM in relation to communication and travel, also challenged the Secretary of State's failure to include a sum for non-prescription medication, but also the imposition of a long stop date of 27th of March for backdated payments. In other words, the claimant was arguing that there shouldn't have been a long stop at all, and this was because the scheme ought to have covered the making of backdated payments to anyone who had been in an initial accommodation for a lengthy period, such as a claimant and her daughter, who had wrongly not received full entitlement to their support under Section 95. On non-prescription medication, the court agreed. On the imposition of the long stop date of the 27th of March, the court disagreed and decided that it was rationally open to the Secretary of State not to extend the scheme to the period before the 27th of March. And then finally, in addition to financial support for essential living needs, there is financial support available for other bits and pieces. So there's additional weekly payments available to pregnant women, children under the age of 3. In the case of those supported under Section 95, those sums that you can see at the first bullet point are just added on to the weekly cash payment of £39.63. There's also a one-off maternity grant available for pregnant women and new mothers, and we've already talked about the additional support available if you've got exceptional needs because of your individual circumstances. Okay, that takes us to 12 o'clock, and I'll hand back over to Justin.
Thank you very much. We've had 3 questions come in, 2 of which are, I think, having read them, effectively the same question. So I'm going to start with the 3rd question, if that's all right, from anonymous attendee. Is there any definition of what constitutes adequate accommodation? Who wants to answer that?
I'm happy to take that one. So there is a definition in Section 95-98, but in terms of what you look at, but really it will depend on the circumstances of your client and the particular facts. So what might be adequate accommodation for a young man, for example, won't be adequate accommodation for a family, won't be adequate accommodation for someone in a wheelchair. So in the round, the definition's quite vague in the regulations, and really you just have to apply the facts to every single situation, and then the court will balance that, all those different factors together, and decide whether accommodation is adequate in the circumstances.
And just to add, there's a fairly comprehensive discussion of what amounts to adequate accommodation in the High Court's decision in the Napier Barracks case called MB. So that doesn't give a definition of what amounts to adequate accommodation. As Alex says, it depends on various factors, but there's an account of the sorts of factors that might be relevant.
Right, and then we have 2 questions that are basically an overlap between the 3 of us. So let me just try and synthesize these 2 questions into one, and then see if we can work out the answer. In the homelessness context, although in theory you can apply to any local authority in England or Wales if you want to, in practice you will get dealt with by the local authority to which you have a local connection. So if you live like I do in Oxford and you apply for homeless assistance from Manchester, Manchester will send you back to Oxford to be dealt with. That is obviously quite a difficult one with asylum seekers because they have no real choice over where they go. And in 2004, the Immigration and Asylum and Immigration Treatment of Claimants Act 2004 provides that asylum seekers have a local connection with the area in which they are accommodated, unless they're subsequently moved to another local authority's area under Section 95, or they are provided with accommodation in an accommodation centre under the Nationality, Immigration and Asylum Act 2002. Our question is effectively, what is an accommodation centre under Section 22 of the 2002 Act? And I think it's a red herring because that's never come into force. Is that your understanding of it as well?
That is my understanding, although in the future might be slightly different, because we mentioned briefly the Napier Barracks challenge. I think we were just discussing before this in the explanatory memorandum to the special development order granting planning permission for an extension to Napier Barracks. It says that the Home Secretary is basically using it as a test for potential future accommodation centres. Now, currently, Napier Barracks is only being used at the moment as initial accommodation. I think they set a maximum limit of 90 days before dispersal, but it may well be that that position changes and that is used for accommodation for longer, particularly when they upgrade it. And it may be that they build new bespoke asylum centres elsewhere, where people can be housed for a longer period of time. But yes, my understanding is at the moment that's not the case, but it's the issues being looked at quite carefully by central government.
Do you agree with that, Hafsah? Oh, you're on mute.
I'm on mute, sorry. My answer was yes, I do agree. I don't have anything to add.
So I'm afraid our two local authority housing officers writing in there, what's happened, happily, is exactly what I say happens in this book here that you can read about. What happened, you're both going to the Code of Guidance for Homelessness, and the Code of Guidance just repeats what the Act says and doesn't bother to tell you that the relevant bit of Act it's referring to isn't in force. So there's no such thing as the second exception to the local connection provisions, that is what you're both thinking about, but there might be in the future. Right, any more for any more? If there are, we'll give it another 20 seconds or so, see if any questions are coming in. No? Well, as no more questions have come in, it just reminds me to thank you all for your time. The link to this and the slides will come out shortly, later on today, early tomorrow, depending upon workloads, editing time, etc. And if anything does come up you want to have a chat about, please feel free to send us an email and we'll try and take it from there. Thank you very much, everyone. Thanks for your time. Have a good rest of the day.